involved in a lot of activities, including our very own chapter of the Federalist Society, along with the George Mason Law Review. He is currently a law clerk for the Honorable Kim Gibson of the United States District Court for the Western District of Pennsylvania. He is an aspiring academic and a prolific scholar. He's already been published in 5 law reviews since graduation. He's been cited in various briefs, including briefs to the United States Supreme Court, as well as by prominent law professors. He also co-teaches a federal court practice class at the Pennsylvania State University Dickinson School of Law. Beyond his publishing success, he is one of the rising stars in the legal blogosphere, and he is president of the Heartland Institute. Please join me in welcoming Josh Blackman.
It really is an honor to be back here. I went to Mason. I was here for 3 years, and just a few months ago, sitting right where you're sitting, and I'm here now, and it's just really, really cool. So thank you to Brooke and everyone at the Second Amendment Foundation. These are very important groups to my heart, so I'm actually really glad to be back. I'm here today to talk about the case of McDonald v. Chicago. McDonald will be argued tomorrow at 10 a.m., and actually basically immediately after this argument, I will be walking over to the Supreme Court, and I'll be getting online. I'll be sleeping this evening to get a good seat for arguments, because they only have the first 50 people get in. So this is actually my last hurrahs before I head off to the Supreme Court. So what's McDonald v. Chicago? On its face, it considers whether the Chicago handgun ban, which basically says you can't have a handgun in your home, is unconstitutional. But this case is not about the Second Amendment. This case is not about fears that the British were starving the streets. This case is not about James Madison, or Samuel Adams, or Thomas Jefferson, or George Mason. This case is not about 1791. This case is about the 14th Amendment. This case is about 1868. This case is about the states trying to deprive free black slaves the right to keep their arms defensive against the Klan. This case is about the radical Republicans in the 39th Congress trying to protect the people of the states. But on an even deeper level, this case is not about guns. This case is about liberty. Liberty protected by the Privileges or Immunities Clause of the 14th Amendment. And that's what we're here today to discuss. And among these privileges and immunities is the right to keep and bear arms for defense of self and property. And that is what the Supreme Court will be considering tomorrow morning. So what the Supreme Court should actually be considering is not the Second Amendment as existed in 1791, but the 14th Amendment and the Privileges and Immunities Clause as it existed in 1868. And that's where we are today. Just going to be a little bit of history. I'm sure you're all familiar with District of Columbia v. Heller. It's right after Lee. And you're on video too, so everyone knows. Anyway, so the District of Columbia v. Heller case was decided in 2008. In a 5-4 opinion by Justice Scalia, he said that the Second Amendment protects an individual right to bear arms. But because it was in the District of Columbia, it only applied to the federal government. As you know, maybe commonly, yet the Constitution on its face only applies to the federal government, does not apply to the states. Only after incorporation through the 14th Amendment do the Bill of Rights apply to the states. For example, the freedom of speech. Back in the early 1800s, that didn't apply to the states. The state could freely abridge your right to free speech. The government wanted to take your property, did not give you compensation. So the D.C. v. Heller case only addresses the federal government. Within days, or actually within hours of the D.C. v. Heller opinion, a bunch of lawyers raced to the courthouse and filed suits in Chicago and California, saying that the Chicago and California handgun bans respectively were basically unconstitutional, citing D.C. v. Heller. The case before the Supreme Court now came from the 7th Circuit in Chicago, in which basically Alan Gurr on one side and the NRA filed concurrent suits saying that the Second Amendment prevents the state of Chicago from banning handgun use in the home. And the case is going to be heard tomorrow. Now, the question presented in this case is very important. The question presented is whether the Second Amendment is incorporated into the Due Process Clause or the Privileges and Immunities Clause of the 14th Amendment so as to be applicable to the states, thereby invalidating ordinances prohibiting possession of handguns in the home. Okay, what does that mean? The Supreme Court will consider 2 possible routes to extend the Second Amendment to the states: due process, privileged immunities. I'm going to address them in turn. The first argument is the Due Process Clause, which roughly provides that no state shall abridge or deny a person's life, liberty, or property without due process of law. This has been the route the Supreme Court has taken to incorporate basically all the amendments to the Bill of Rights: freedom of speech, freedom of religion, freedom from lawful searches and seizures, property can't be taken without just compensation. These are all protections in the Bill of Rights which have been incorporated into the Due Process Clause. There's various different tests that the Supreme Court's used. The most famous one is called the implicit in the concept of order of liberty. If there's a liberty interest that's so strong, it has to be in our system of liberty, so it basically applies to the states. Today, with the exception of the Third Amendment, the Seventh Amendment, indicted by grand jury, and the Second Amendment, all the rights in the Bill of Rights have been extended to the states. And right now, the Second Amendment is the ugly redheaded stepchild of the amendments because it has not been incorporated. And that's exactly what we're having tomorrow. So this is a first route to incorporation. I'm not really going to spend a lot of time on it because it's basically a slam dunk. Here at George Mason's, Professor Nelson Lund wrote a great article in the Syracuse Law Review discussing how the Second Amendment should be incorporated into the process. He'll do a much better job explaining than I will. He's a great historian. So I'm going to focus more on privileged immunities. But suffice to say that if every other right in the Bill of Rights is incorporated through the Due Process Clause, the Second Amendment will happen. Where this case becomes fascinating and why this is such an interesting case is because of the privileges or immunities. So what are privileges or immunities? I mean, how many of you have heard of the Privileges or Immunities Clause? All right. And this is why we're at George Mason, because all the hands just went up, and that makes me really, really proud that you guys are actually learning this in the Constitution. Really proud. The 14th Amendment provides, in short, no state shall make or enforce any law which will abridge the privileges or immunities of citizens of the United States. Okay. Now, there's another clause in the Constitution that's similar to that. In Article 4, there's the privileges and immunities. The first one is and or. They're actually different, but the difference is not really significant. Article 4 provides that citizens of each state shall be entitled to all the privileges and immunities of citizens in several states. So, we're at George Mason. We study the Founders' Constitution. You probably consider yourself originalists of various stripes. So how do we do originalism? We go to original public meaning. How would the phrase privileges or immunities have been understood in 1868? And the major reason, the main influence on that meaning was the Privileges and Immunities Clause, because that was a very commonly accepted phrase. Privileges or immunities was a term of art in the 19th century for these liberties which people possess. And in a very famous opinion written by Justice Bushrod Washington, who was actually George Washington's nephew, so he probably knows what he's talking about with the founding era documents, he wrote an opinion in Corvell v. Coriel, which was when he was riding circuit in the Pennsylvania Circuit Court. And he said that the privileges or immunities are these, quote, rights that are in their nature fundamental, which belong of right to citizens of all free government, and which have at all times been enjoyed by the citizens of several states. These are basically the rights which no government can deprive a person of. They're not political rights like the right to vote or the right to have some sort of franchise or something of that sense. These are natural civil rights that are pre-existing in any civil government. And these are what the rights that are protected by the privileged immunities. And among these are the right to property, the right to contract, right to freedom of worship, and most importantly for this case, the right of self-defense. And implicit in the right of self-defense is the right to keep and bear arms for defense of person and property. So from an original public meaning perception, this is how this term was understood back in 1868 at the time of the ratifications. So while we might disagree of whether the scope of these rights, most people agree that as understood in 1868, this was among the rights protected. And this Corvell v. Coriel opinion, you'll probably read it at some point in your common law class. It's a very good opinion discussing what these rights are. But beyond Corfield, privileges or immunities adopted a new meaning by 1868. If you put yourself back in this mindset of the Reconstruction era, you basically had these southern states who were thumbing their noses at the federal government. They were authorizing lynch mobs to chase down African Americans to the street, these freed slaves. They denied freed slaves the right to make contracts. They denied them the right to own property. They denied them the right to bear arms. These were basically people who had nothing to protect them. And you had the Klan and all these other groups just going after them. What the federal government wanted to do, and specifically the radical Republicans in the 39th Congress wanted to do, was to protect these people. And what better way to protect them than to extend the protections of the Bill of Rights to these people? So in addition to these natural rights, the Privileges and Immunities Clause also embodied a lot of the Bill of Rights, the first 8 amendments of the Constitution. But it's not exactly all of the first 8 amendments of the Constitution, for various reasons, which I won't go into. Some of the provisions of the Bill of Rights are called federalism provisions. For example, the Establishment Clause. The Establishment Clause says the Congress should make no law establishing a church. Well, in 1791, that meant a state could have a state-endorsed religion, and the Congress couldn't tell them not to. That's not really an individual right, that's a federalism provision. But a lot of the provisions in the Bill of Rights are individual rights which you hold, for example, the right to bear arms. If you go back to 1868 and you read many of the speeches that were given by these framers, specifically Senator Jacob Howard, he was very clear in saying that the rights in the Bill of Rights are thus incorporated into the states, that they're basically extended to the states. So no longer can a state search a free slave's home without a warrant. No longer could a state tell a free black, you can't have a gun, only a white person can own a gun. These are some of the very important things. In the words of Professor Amar, the 14th Amendment aimed to incorporate various rights and freedoms in a subtle way that meant both more and less than the understanding of the Bill of Rights. But I want to take a step back. Well, I've been using the word incorporate, and that's kind of an odd term. It's really an odd term because that's anachronistic. If you go back to 1868, that word was never used. The word incorporate was really a concept developed by the Supreme Court in the early 20th century to kind of extend rights to the states. And it's kind of an odd idea. And I think it's kind of wrong to view the incorporation doctrine as merely injecting the 1791 amendment to the states. The way I kind of look at it is that what they're actually applying to the states is not how the right was understood in 1791, but how the right was understood in 1868. In 1868, when the 14th Amendment was passed, it was kind of like taking all the knowledge of how the right to keep and bear arms was understood and sending that to the states. Think of it like almost like being frozen in amber, so to speak. That how the rights were understood in 1868, that is what's protected, not what's protected in 1791. And that has very important implications, because a lot of the attorneys briefing McDonald in Chicago made this mistake. They were briefing about 1791, about the British disarming the colonists, all that stuff. That's not relevant. What's relevant is how was the right understood in 1868. I kind of analogize it to trying to incorporate a VHS into a DVD player. Okay? They're similar, they maybe look alike, they accomplish similarities, but they're different. What we have to look at is how this right was understood in 1868, and this is the privilege of media we aim to protect. Okay. So, moving forward, I just want to say, why is it that we would prefer the privileges or immunities clause over the due process clause? And this is really the important element in this case. The Supreme Court has been incorporating rights through due process for nearly 85 years, or almost 100 years. There's a lot of existing precedents on this. So the question is, why do we want to open up this new door, or the way I phrase my article, why would they risk opening up Pandora's box to try and find a new way to extend rights to the states? To answer this, it really goes to the crux of originalism. I think anyone who watched Justice Sotomayor's nomination, or Justice Alito, or Justice Roberts, saw these judges up there saying that we should interpret the Constitution as it originally meant. We should apply the law as it's written. If we take this as our starting point, that law should be applied as they're written, this really makes a lot of sense. In order to go through the due process clause, the Supreme Court has to engage in a lot of doctrinal contortions. By its very text, due process implies process, procedures, things of that nature, not substantive rights. That's not to say that there are no such substantive components of due process, but for the most part, the due process clause refers to processes. You can't deny someone these liberties without giving them process. The privileges and immunities is better. It's historically accurate. It does speak to substantive rights. It speaks to the right to bear arms, the right to property, the right to freedom of worship, the right to freedom of speech. These are rights which should be protected by the Constitution. And rather than trying to shoehorn rights into the due process clause where they don't fit, we should be using the privileges or immunities clause. So if we are originalists, which I don't know if any of you are, or if any of the people on the Supreme Court actually are, maybe they're faint-hearted originalists perhaps, this is a way to align the Constitution with its original meaning. And one of the more compelling factors is stare decisis. Very often, the court will ignore originalism when there's a compelling precedent telling them to do otherwise. This is not such a case. The privileges and immunities clause was gutted by a case called the Slaughterhouse case. It was like an 1873 case, which really no one's relied on. There really is no big precedent standing in the way that anyone's relying upon to get PRI into play. If the Supreme Court is willing to, they'll have to turn over a 130-year-old precedent no one really cares about, and they can once again maybe give the Constitution its original intended meaning. And if they do that, perhaps we can take a step forward to protecting some of the rights which have been disparaged by the Supreme Court going forward. Now, how do we do this? One of the difficult parts about the privileges and immunities jurisprudence is it's a blank slate. There's nothing there. It's basically writing with nothing. So what I propose in the article I wrote with my co-author Shapiro is that we adopt the framework for Washington v. Glucksberg. You might remember this case. This case involved whether a person has a constitutional right to assisted suicide. So if a person, Jack the Morphine, that entire deal, can a person go to a doctor and say, I consent to you killing me, you can kill me? Compassionate suicide, basically. And this was a case that the Supreme Court considered whether someone has a right to this. In that case, the Supreme Court proffered a two-factor test to determine whether there's a substantive right to assisted suicide or anything else. The two factors are, number one, the right has to be deeply rooted in our nation's history and traditions. Number two, the right has to be clearly defined. What this test actually does is it discerns whether in our history and traditions of our law, there's some kind of right, some sort of substantive liberty that the courts can protect. And if the court uses this approach, they actually went back and said, well, in the history of our country, you do not have a right to suicide, and many times it's a crime, so you cannot possibly have this right as a positive matter of law. So they said that this does not work. But this is a different application than for the right to bear arms. In fact, I would argue that the right to bear arms would satisfy this. If you go back to the 1860s and you look at how rights were understood, the right to bear arms is really deeply rooted in our nation's histories and traditions. One of the precursors of the 14th Amendment was really the Civil Rights Act of 1866. This was basically passed before the 14th Amendment. The 14th Amendment was in 1868. This was 1866. What this does was it laid out a number of rights and freedoms that all the freed slaves can get. Among these were the right to bear arms, the right to property, the right to contract. These are things which the 39th Congress wanted to give, actually the 38th Congress wanted to give to the freed slaves. If we understood how deeply rooted, how the Congress didn't want these people who were being marauded by the Klan to be helpless, you see that there's a deep history and tradition of guns in our culture. This is a Second Amendment event correspondence. I don't think that too much, but guns have been pretty important in our culture going back for centuries. And that's something that's very important. And also, it can be clearly defined. Unlike perhaps an esoteric right like the right to compassionate suicide, this is clear. This is asking someone to keep a handgun in their home for self-defense. If the right to self-defense is a pre-existing right, as Scalia said in Heller, if this is a right which we hold deeply before any civil society existed, this right which from the state of nature we left, and we have the right to self-defense, it's the most basic natural right, I have a very difficult time seeing someone think there's not a clearly defined right that's deeply rooted. If the Supreme Court listens to me, which it probably won't, and adopts this two-factor test, I think it's pretty clear-cut that they can incorporate it. That's not to say they won't incorporate it into due process. I think that's a slam dunk. But if they do go down the road of privileges or immunities, I think it'll be a much more honest framework. Now I want to do a little counting heads, trying to go through the different votes and seeing how I think this power can possibly come out. Heller, as you know, was 5-4. So you had Scalia writing, joined by Thomas, Roberts, Alito, and the swing, Kennedy. They basically need those 5 votes to get incorporation here. I think you have solid 5 votes for incorporation. I can't see Anthony Kennedy voting to strike down the DC gun ban and not voting to strike down the Chicago gun ban. They're basically equally draconian. The question, though, is privileges or immunities. Which of the originalist justices will actually do the right thing and find that the privilege and immunities clause protects this? I'm not sure about Roberts. He claims he's an originalist, but I think he's more of a precedential guy. If you read his concurrence in Citizens United v. FEC, which was a Hillary moving case, he had this entire long concurrence just on precedent, went to overturn precedent. The way I read it, I think he actually might be willing to strike down Slaughterhouse. I'm not sure. He really likes precedent, and he might just say, just go through the process, it's easier. Alito is probably in the same boat, because Alito actually joined that citizens concurrence. Now it gets tricky with Scalia. Scalia is between a rock and a hard place here. Scalia hates substantive due process. He loathes it. He calls it flotsam. He just thinks it's absolutely reprehensible. For almost 25 years, he's been writing how the due process clause does not protect any of these substantive rights. But he has to incorporate here. He's never been confronted as a Supreme Court justice with the opportunity to actually incorporate a right through the due process clause. So he's in a really odd spot. And I proffer to Justice Scalia that, Your Honor, if you wish to be consistent with your ideals, you are free to use the privileges or immunities clause. You always say that the due process clause refers to process, and that's wrong, and I agree with Scalia there. Privileges and immunities is substantive rights. If you look at the history of this text, you know that this is something that's protected. Being originalist, incorporated. So that's where Scalia is. And it's going to be really interesting to see if he joins this opinion, because he is probably very afraid of opening up the Pandora's box. He doesn't want this wide open rampage of unenumerated substantive rights coming in, because as you probably know, Scalia doesn't like unenumerated rights. He's not a fan. Read his opinion, Trotsky, Granville, and others to know that. Now we have Justice Thomas, who's a dear friend to this law school. Justice Thomas, I think, is the safest bet to write an opinion on privileges or immunities. He's written elsewhere, before he was a judge, let me find the quote. In 1988, Clarence Thomas wrote, before he was a judge, the natural rights and higher law arguments embodying the privileges or immunities clause the best defense of liberty and of limited government. Moreover, without a recourse to a higher law, would then our best defense of judicial review. A judiciary active in defending the Constitution, but judicious in restraint and moderation. That was Justice Thomas in 1988. He's a big fan of natural law, and he's a big fan of not following precedent when it's wrong. As you probably saw in his opinion in Citizens United, he's one of the dissented, saying strike down everything, get rid of the disclosure requirements. Last term in the Voting Rights Act case, the other 8 justices said, well, this is probably unconstitutional, but we'll uphold because of precedent. Clarence Thomas dissents saying, no, that's garbage. Read his dissent in Raich, his dissent in Kelo is breathtaking. I mean, he does not like precedent for the sake of precedent, especially when it's common law, because you probably know this, but stare decisis should be weaker for constitutional law cases. Why? It's a lot harder to amend the Constitution. If there's a statute you don't like, you can change it. So stare decisis should be stronger. With the Constitution, you cannot change it very easily, so judges should not be as bound by bad con law. So I think Clarence Thomas might be a good bet for privileges and immunities incorporation. Now, Anthony Kennedy. God knows. He has a very interesting jurisprudence. And there's actually an interesting book by Helen Knowles recently called, I forgot the name, but it's a very good biography of Anthony Kennedy. Oh, that's it, The Tie Goes to Liberty by Anthony Kennedy. And she paints a very interesting picture of how he's an interesting type of libertarian. His big thing is autonomy. If you read his opinions in Lawrence and otherwise, he likes when the government leaves people alone. He doesn't like when the government bothers people. So if he sees this as the privileged immunity as a way to give people their personal autonomy in space and mysteries of the universe and such, you can see that he might be willing to join Justice Thomas. But my prediction is Thomas gets 1 vote for PRI, and that's it. As far as the Justice Stevens, I'm predicting this is probably his last term, as Tom Goldstein predicted. He's probably right. This is probably Justice Stevens' last term. Look forward to a really epic dissent. His 90 pages in Citizens United was brutal. I mean, it was really, really good. I mean, it was really thorough. So expect a really epic dissent from this one. Justice Ginsburg does not like guns at all. She's not going to incorporate. Justice Breyer, he actually wrote a dissent in Heller where he basically said, well, even if the Second Amendment protects individual rights, guns are bad, they cause crime, they're dangerous, we should ban them anyway. Expect something similar in that sense. Justice Sotomayor, in the only opinion she confronted the Second Amendment when she was on the Second Circuit in Maloney, this was actually a case not with guns, but with nunchucks, like Ninja Turtles, like little sticks with the chain in the middle. I don't know what those are, but apparently this is some kind of weapon, and those were banned in New York. And she was on a panel that wrote a per curiam opinion saying that the Second Amendment was protected. I can't imagine she votes to incorporate this case. So that's my prediction. But I really think that reviving the privileged immunities clause will align our Constitution with notions protecting our most fundamental and sacred liberties. And McDonald is really the case to do this. This is a time, this is a place, and I hope the Supreme Court takes up that gauntlet. Seldom does a case present itself that is so ideally suited to restore the original meaning of the Constitution. What made Heller so cool was that there was no precedent. It was a blank slate. They could actually get it right. They didn't need to deal with all these decades of obscure precedents that weren't right. This is exactly the same case, but even better. Because rather than just focusing on one clause, the Second Amendment, this is the 14th Amendment. This has broad implications. And the Supreme Court gets it right here. They will do a lot to make things on the right path. And I think that through this approach, the Supreme Court can really promote liberty, but keep Pandora's box sealed. Thank you very much. I hope there's lots of questions. I mean, whenever I ran these events, I couldn't stand when the guy ran on for the full hour and no one could ask questions. So please feel free to ask questions about the Constitution, Heller, McDonald, anything you like. I'd be happy to stay as long as you need. Corey.
I noticed that when you were speaking about the possibility of the liberal justices and how they'd vote, you focused directly on how they would react to the issue of gun rights. Do you think it's possible that maybe, say, Sotomayor decides to incorporate their privileges or immunities in order to open Pandora's box to give an advantage to these to the creation of unenumerated positive rights?
Well, that's a really interesting argument. One of the interesting things about McDonald is it's created very odd bedfellows. Liberals like this. Libertarians like this. The Constitutional Accountability Center, which is run by Doug Kendall, who is a fairly guy on the left. You probably know his work. He had a brief joined by Jack Balkin, who's a prominent liberal professor at Yale, Randy Barnett, who's a libertarian at Georgetown, Steve Calabrese, who's one of the co-founders of the Federalist Society, who's a professor at Northwestern. And he got all these people to join this brief saying that privileges and immunity should be restored. I argue, what's the next step? If you read that brief, it's very good at saying that the privileges and immunities clause should be restored, should be given its original meaning. But if you actually look at what some of the other scholarship on the left is, I actually wrote about this in my paper in the Constitution 2020 project, which is this ACS blueprint of what the Constitution will look like in a decade. They seek to use the privileges and immunities clause to imbue positive rights into the Constitution. example, the right to social equality, right to education, right to health care, you name it, it's in there. And the way they do this is through levels of generality. For example, in Corfield v. Coriel, Justice Bushrod Washington spoke of the right of protection, which basically means the government has to protect you. Okay, we enter civil society, we delegate our executive power to the state, and the executive makes sure we don't get hurt. Fine. But if they brought this to a higher level of generality, that includes things like the right to health care, because we have to protect our citizens. It's a very slippery slope, and that's why I propose a Glucksberg framework. I rather look towards history than forward. Look to what the amendment meant in 1868, not what certain professors want to be in 2010 or 2020. And I think by using the Glucksberg framework, just looking at the historical aspect, you prevent all these positive rights. Just so you know, difference between positive and negative rights. A negative right is something like Congress will make the law of freedom of speech. It doesn't give you a right to free speech. It just says Congress can't infringe it. Or it says Congress cannot deprive you of arms. You'll have the right to arms, but Congress can't infringe it. In contrast, though, a positive right is an entitlement. For example, you have the right to Social Security. Okay? You have the right to Medicaid, Medicare, health care. Name it. It's a public education. These are positive entitlements. So, to Corey's question, do I fear that some of the liberal justices will proverbially open up the Pandora's box by voting to perhaps saying, yes, the Privileges and Immunities Clause should mean something, the Chicago gun ban is fine? That's a very distinct possibility. What I've actually considered is a 4-1-4 split. So bear with me for a second. You have 4 votes for incorporation through due process. Thomas votes by himself saying, I don't incorporate through due process, I will only incorporate through privileges and immunities. Then you have 4 votes saying, we don't incorporate, but the Privileges and Immunities Clause means something. What that would actually mean is you have 5 votes saying Privileges and Immunities Clause means something. That would be a really bizarre split, and I blogged about this. It's not beyond a possibility. What that would actually do is strike down the Chicago handgun ban and also open up privileged immunities, because then PRI will be in play. And you can be almost certain that in the near future, after this case, you're going to see a lot of cases being filed under PRI. There's a host of rights. The Constitutional Accountability Center published a report called The Gem of the Constitution, where they kind of laid out their blueprint of what the PRI clause will mean going forward. And it's very important, and I think that's why I stress so much the historical framework of Glucksberg, that this is not turns to sort of open license to imbue the Constitution with whatever positive rights du jour people love. I think that's something that the Supreme Court should really do. Questions? Mr. Aft, my friend.
The least dangerous branch doesn't exactly have a ton of institutional capital, and it seems to have spent a lot recently on Citizens United. To what extent do you think McDonald could just fizzle out to be, incorporated under due process? Maybe Stevens will have another 90-pager, but otherwise not much interesting coming out of the case given the recent ripple in the water they just put out.
That's a very strong possibility, and that probably will happen. But I think you have to think of Scalia. He's old. He's old. The court's going to change. We have a opposition party president for the next few years. There's going to be different appointments. One of the things the originalists can do in the court now is, to the extent possible, cement precedents that will actually make original the rule going forward. Although any precedent can be overturned, if the Supreme Court adopts a test today, and say if in 5 years or 10 years the Supreme Court looks totally different, and say there are, say, 6 Democrat nominee candidates, they're going to have to do a lot of doctrinal contortions to get rid of the old press and say why it's wrong. So to that extent, it's kind of, incumbent's the wrong word, but the originals in the court today might feel the need to perhaps lay out a framework that will protect the original meaning of the Constitution and perhaps not allow future justices to deviate from that meaning. So sure, they can just do a simple opinion and fizzle out. And yes, Citizens United burned a lot of capital, but the Second Amendment is Scalia's baby. Thomas doesn't care, he's going to concur no matter what, he doesn't really care what people think about him. That's cool. But Scalia has said that Heller is his favorite opinion. This is his legacy. He wants this. I mean, if you look at Scalia, Crawford v. Washington, a couple other major originalist cases, the denigration of legislative history, and Heller. These are his contributions to the law. And if he wants to leave his legacy, this is what he's going to do. Get it right. Okay. Questions? Any other questions?
Who writes the majority opinion?
It depends. If they prevent, okay, so my feeling is that if they prevent Clarence Thomas from concurring, it'll be a Scalia. Otherwise, it'll be a Kennedy. So it'll probably be a Scalia or Kennedy. I don't think the Chief's going to write himself. This is going to be a Scalia or Kennedy opinion. Anthony Kennedy, Justice Kennedy had a very interesting role. If you read Joe Miskubik's book, American Original, she discusses at length Heller, and kind of compromises that the court had to make in Heller to strike down the DC gun ban, but not open things up too much. So if you read Heller, there's a lot of limiting dicta. For example, there's certain called sensitive places where guns can be banned, and certain long-standing prohibitions on guns. For example, people who commit felonies can never own guns, or minors can't own guns. Justice Kennedy plays a very important role because he probably believes in liberty, but he doesn't want this to be some sort of free-flowing right. So it's either going to be a Kennedy or a Scalia opinion, if I had to guess. If Heller's any indication, it'll probably be Scalia again, because that's just his baby. He's gonna give it to himself. In the back?
You mentioned that now is the time, so I'm wondering, after over 100 years of, unfortunately, I think, ignoring the 14th Amendment, why is now the time?
You have to look at the composition of the court. I mean, you're in law school now. You kind of take for granted that originals mean something. For almost, I don't know, how many centuries, the original didn't really mean anything. If you look at the court, going back to the Burke Court, the Warren Court, forget the New Deal Court, the courts weren't actually interested in what law meant when it was written. They were interested in more in sense of fairness and justice, and there's nothing wrong with that. But we just so happen to have had a number of justices who proclaimed fidelity to the original meaning of the Constitution. I don't know how long that will last for. So if we take from the normative perspective that original is good, we should stick with it. I think we have 5 votes for it. Next year, we might have 2 more retirements. Justice Ginsburg is probably not going anywhere, but assuming we have 2 more retirements, it could swing the court the other way. Who knows what happened? I mean, I've read about Justice Kagan, who I think is probably the next pick. She's a very effective uniter. I mean, as the dean of the Harvard Law School, she was very effective in bringing people from Chicago. She brought Cass Sunstein there. I mean, she brings conservatives, libertarians, liberals. She brings people together, and she might be able to whisper into Justice Kennedy's ear. And who knows what will happen? If the court wants to do it now, would really be the right time, because if they don't do it now, if we get, like Adam mentioned, wishy-washy opinion, it's basically a dead letter. Just like in Heller, if the Supreme Court did not strike down the gun ban in Heller, the Second Amendment will be nugatory. It would not mean a thing. So this is really the opportunity to do it. Yeah?
It seems like Heller kind of created a pretty definite line about what sort of constitutional limits can be placed on purchase and possession of handguns. And if Heller's basically incorporated, I just have this intuition that there's going to be more limitations on handgun possessions because that line is going to be more defined. And I can see states creating more impositions on ownership as a result of this.
Well, Heller doesn't require more limitations. The Constitution is kind of a floor. States can always provide more protection. So even if in the District of Columbia, so the Supreme Court tells D.C., you don't have to allow guns in sensitive places, for example. But if a state wants to, they can. Liberties are ratchet. They can always add more liberty. They can always make guns easier to obtain. Virginia, for example, my former home, will never tell people, you cannot own a gun in your home. I don't care what the Supreme Court says, because they'll interpret the Virginia Constitution to say you have the right to bear arms in your home. California, District of Columbia, or New York, or Boston, they have to go at the bottom level where the Supreme Court says. Now, what's interesting about this case is the nature of the Chicago handgun ban is not even in play. It wasn't even briefed. If the Supreme Court decides to incorporate it, they will have to actually reverse it and remand it back from the Seventh Circuit to actually determine whether this ban violates the Second Amendment, or actually the 14th Amendment to the due process immunities, or whatever it is. At that point, Judge Easterbrook will most likely write a very good opinion saying, well, the Chicago handgun's bad. He couldn't do that this time, because that wasn't really the issue in the case. The issue was just whether it's incorporated. That's where the question presented focuses solely on incorporation. But you're right. I mean, the opinion by Justice Scalia did include a lot of limitations on, you can't have machine guns. You can only have guns that are in common use at the time, which I think distorts the opinion from the United States v. Miller. But that's kind of an old hat that doesn't really matter now. All that matters now is whether the right's incorporated. And I guarantee you have future circuit cases which will define the contours of what that right means.
I've heard a bit about the sort of the political wrangling in getting this case through between the NRA and libertarian groups and other groups who've sort of been, I think, wrangling to take the lead on this. Can you talk a little bit about what's gone on and what the implications are for future cases or for this trail of?
Well, the NRA and Alan Gura, and I think one of the Nordic plaintiffs in the back, is that?
No, not plaintiffs.
Attorney.
I know this is the Nordic lawyer is
Okay.
Don Kilmer, and I'm actually with the Calguns Foundation, so I'm actually plaintiff for one of the California lawsuits you mentioned earlier.
Right, so maybe we can talk about that, the California in a minute, if you like, but I'm going to talk about the Chicago case. The history of the NRA in these cases is actually kind of interesting. Going back to D.C. v. Heller, which I was a research assistant for Alan Gura, the NRA basically tried to sabotage the case of Alan Gura. The NRA was not confident of bringing this case to the Supreme Court. They were afraid that if we bring this case to the Supreme Court, we'll lose, and then we'll lose bad, and we'll lose lots of memberships and membership dollars. So they were kind of confident in just maintaining the status quo. They wanted to just leave things they are, fight the Brady campaign, leave gun laws that they are, and not challenge it. And they actually tried to, on certain litigation tactics, they tried to kill Heller. And only through a beautiful opinion by Judge Lawrence Silverman in the D.C. Circuit, the case prevailed to go into the Supreme Court, where only one plaintiff, Mr. Heller, was found outstanding. In this case, you actually had dual petitions. Right after Heller, you had the NRA and Alan Gura run to the Southern District of Illinois and try and file suits challenging Chicago handgun men simultaneously. And they both filed the suits. They both lost. There was NRA v. Chicago, and there was McDonald v. Chicago. McDonald was Gura's case. They both applied for certiorari to the Supreme Court. The NRA granted Gura's petition, but not the NRA's petition for certiorari. So really, the NRA was not a party of interest in this case. What happened about a month or two ago, which was kind of a really interesting thing, was that the NRA basically filed a motion for divided war arguments. Paul Clement, who's one of the most gifted advocates of our time, and a former Solicitor General, the guy, go listen to him in arguments, go listen to the MP3, he's good. He filed a motion saying that we're not confident that Alan Gura will accurately discuss due process, and we want to discuss due process ourselves, and they kind of intervened. So there's a lot of wrangling. So why is it wrangling? When I first came up here, I said this case is not about guns. This case is about liberty. The NRA is about guns. They only care about the guns. They want the easy victory. They want this thing to be incorporated. They don't want to focus on these newfangled unenumerated rights. They don't really care about that. In fact, they're actually afraid that this might offset Justice Kennedy, and he might swing the other way. There's a lot of fear, and I think the fear is rational. So that's why the NRA intervened in this case. There's a lot of wrangling. You want to talk about the Calguns, the Nordic case? Introduce yourself. You can.
So I'm Brett Thomas, and I'm
Turn the camera on.
I'm sorry.
Just turn the camera. Yeah.
There you go.
I'm Brett Thomas, and I'm on the board of the Calguns Foundation, and we're a nonprofit out in California that our original mission was to help defend people who had been arrested for violating California's guns laws, which are so Byzantine that very often the police didn't understand that the things they were arresting people for weren't illegal. And with a very minimal legal defense, you can often get these people out of jail and get the charges dropped, but there was no organization to really found that. So we've been very successful in that, but frankly, our donations are beyond even what was necessary for that, and so we actually have been funding as well some more proactive legislation to try to roll back some of these gun laws. So we actually have been involved in, you alluded to, there was some number of California lawsuits that have been applied, that have been filed to try and overturn this stuff. And with me is Don Kilmer, who was the lawyer on the Nordic case. And the Nordic case actually is a very long-standing series of cases that have been running for many, many years. 10. That actually my foundation is not technically involved in, but the bottom line of it was that the Nordics run gun shows, that's their business. And so various counties in California decided to outlaw gun shows. Don has been helping them challenge those laws for a very long time, and happened to be at a very ripe spot that when the Heller decision came down, was able to then re-argue with the Heller piece in front of the Ninth Circuit Court of Appeals, and then argue that the 14th Amendment was incorporated against in California, and therefore that these laws should be overturned. And while unfortunately he wasn't able to convince the court that those laws should be overturned in consequence, the court did in fact agree that the 14th Amendment was incorporated the second under due process against the state of California. So Don is in fact the first lawyer to have won such a decision out of the courts. Of course, that has now been stayed pending what we hear from McDonald at the Supreme Court.
All right, thanks so much.
Sure.
All right, so those are the different litigations. So there's litigation in the second, litigation in the ninth. There's also litigation in the second, which was with Justice Mayor. She has her panel and then Chuck's for Michelangelo weapons. All right, other questions? Keep it coming. Sir?
What are your thoughts on the interplay between the states and the federal government? You made a remark that the Second Amendment will be a floor, that the states may not go below that. But what about, for instance, a state that wants to protect the right even more vigorously than federal statute, like the Martha Stewart problem? She's a non-violent felon. Federal law says she can't own a gun for the rest of her life. There are states that do permit non-violent felons to have guns under their own state constitution. And basically we're going to run into this conflict where the ATF is saying, we are going to enforce federal law in your state whether you want to or not.
Yeah, unfortunately, the supremacy clause kind of gets in the way there.
It does.
Yeah. I mean, as much as people love the 10th Amendment and things like that, the federal law is the Supreme Court of the land, and if there's preemption or some supremacy conflicts, the federal statute must prevail. I don't think there's much you can do about that. But perhaps to answer your question at a different level, and perhaps to Karuna's question before, if the state wants to provide more rigorous and robust protection that is not preemptive, I think that's good. I think to a large extent, opinions like Heller and opinions like McDonald, if they're written the right way, can make people realize that, hey, guns are not bad.
Well, to follow up on that, for instance, the federal statute that prohibits felons from having guns for life actually has a provision that is currently not funded by Congress that says ATF can do a background check on you afterwards and see if they should basically restore your rights. Doesn't Heller and maybe even McDonald tangentially almost compel the funding of that program now?
I'm not familiar with the statute. I mean, Heller had a couple lines about these long-standing prohibitions, and I think included among which felons can't possess arms, which I think that would seem to cut the other way. I think there's an article in the Harvard Journal of Law and Public Policy. It's called, entitled Martha Stewart Own a Gun. Yeah. It was published, I think, in the last 6 months. It's a good read about whether nonviolent offenders can bear arms and whether, in fact, there was a historical ban on felons or nonviolent felons from bearing arms. I don't know much about that clause, so I can't speak to it, but it's an important question. Sure.
I think it's an NAACP brief, but what do you think about PRI only applying to citizens versus due process applying to citizens?
That's a really tricky argument. The text of you should all keep one of these in your breast pocket. They come in handy all the time. The text of the 14th Amendment says, and I quote, "No state shall make or enforce any law which abridges the privileges or immunities of citizens of the United States." The Due Process Clause says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." So we got citizens and we got persons. The citizens is much more narrow, and the NAACP did make this good point. The way Alan Gurr approaches the brief, and I haven't really focused too much on this, and it's a tricky textual situation, is he hung his hat on the Equal Protection Clause. So say that if the law protects people, then it should also protect non-citizens. And that's why he argued it, because the Equal Protection Clause applies to all persons, not just citizens. So if the Supreme Court wants to, they can probably go down that route. I mean, I don't know if you read Bowling v. Sharp, for example, in common law. So you had Brown v. Board of Education. And in Brown v. Board, the Supreme Court said, well, the Equal Protection Clause does not allow segregation in schools. Okay, that's fine. That's a state school. But there was a companion case. There's a school in the District of Columbia. And there's a problem. The Fifth Amendment, which applies to the federal government, has no Equal Protection Clause. It doesn't exist. I mean, go take out your Constitution. There is no Equal Protection Clause in the Fifth Amendment. So the 14th Amendment Equal Protection Clause can't possibly apply to federal schools. So what did the court do in Bowling v. Sharp? They hung on due process. They said, well, it's part of due process. You can't segregate a school. So I don't think that will be an issue. If the Supreme Court wants to go there, they'll find a way to go around it. That's not going to be a hang-up. Text of the Constitution doesn't really matter. I shouldn't say that, but I mean, it won't, that will not be a hang-up. I mean, that might be an issue in a dissent somewhere, but Stevens will definitely rip him on that in his dissent. If he writes his epic dissent, there'll be a lot on that, but I don't think that's going to be a hanging issue. Questions? Other questions? Any other questions for a George Mason person who just graduated on clerking, law jobs, bar review, anything else? Because I hope to maybe shed some light. Because I just graduated here like 9 months ago, so maybe I have some fresh wisdom I can impart. Anything? No? Rebecca?
How can people get involved with the Harlan Institute?
Oh, what a wonderful question. And you just gave me a wonderful plug. The Harlan Institute is a nonprofit. Oh, I love plugs. The Heartland Institute is a nonprofit which I started with my friend Jakob Roth about a couple months ago. And our aim is to teach students about the Constitution, about the Supreme Court. And we're doing this through using Web 2.0 and interactive social media. As you may know, I started the Fantasy SCOTUS Supreme Court League, which is a Supreme Court League for the Corey is doing his little fist bump there. The Fantasy SCOTUS is a fantasy league for the United States Supreme Court. We currently have over 4,000 members who avidly predict every single case before the Supreme Court. Apparently some of them cheat, but for the most part they're honest. And one of my aims in the Harlan Institute is to bring Fantasy SCOTUS to high school students. I want kids to know what